On Hard Knock Right today, with Atlantis American, we're talking about Sir Isaac Newton, Sir Francis Bacon, Josiah Bartlett, Sir and Yvonne. America's founders included medical scientists, physicians, knights. Josiah Bartlett signed the Declaration of Independence for the state of New Hampshire. The Kent English tradition of magistrate judges came from physicians, medical scientists, and knights. Where are they? You can't find them. Bar Association accreditation doesn't qualify graduates for medical science, ruling and litigation, or adjudication. Bar Association exam doesn't cover empiricism, doesn't cover Sir Francis Bacon. It doesn't cover Sir Isaac Newton. Sir Isaac Newton published Principia in 1666. You don't need to know anything about it to qualify for the Bar Association in the United States. The Bar Association membership doesn't qualify for adjudicating, litigating, ruling on medical science. The medical science doesn't change when a non-medical scientist rules against a physician, rules against a patient. The Bar Associations don't advance the rule of law, by knowing nothing about medical science, by knowing nothing about physics, by knowing nothing about medicine. We're talking about reintroducing medical science community standards into America's malpractice system, into America's legal system today. There are 65 to 102 other traditions of Hippocrates, traditions of superior horses, traditions of good shepherds. Medical science community standards are the judge of malpractice. In fact, medical science has always been the judge of physicians. The question being, why would you have a non-medical scientist oversee a case where medical science is at issue? Physicians don't come to work to do harm. Physicians don't sacrifice their youth and treasure to do harm. Physicians don't come to work to hurt people. Neither do medical scientists. Nobody is harder on physicians than medical scientists, than those that are medical scientists, including those that happen to be physicians. We don't need non-physicians, non-medical scientists overseeing such cases. The Hippocratic Oath, to be superior in horses, to do no harm, to practice, isn't one that the Bar Association members have taken. How could they possibly be qualified to make sure that we do no harm? The variation between states on life expectancy doesn't correlate in any way with variation in litigation of malpractice cases. The system isn't working. So advancing the rule of law requires medical science. Those that are qualified in medical science, community standards, and malpractice, which is a town-by-town, state-by-state effort. There are folks that are trained to reintroduce the Kent English tradition of magistrate judges. We think that's probably a good thing. Our founders included legal professions other than the Bar Association, other than reading lawyers. How did you learn about law? Reading. There were physicians at our founding. There were medical scientists at our founding. And there were knights. And that system of alternative legal sects, alternatives to the Bar Association, is where we can draw from for our magistrate judge system. The Bar Association is a fad that originates from Civil War Reconstruction. Bar Association is a legal sect that doesn't make it all the way back. It goes back only to 1878. The Bar Association has no constitutional protection, has not accredited physicians, physician law or medical science law. The Bar Association has not enrolled physician members, medical science members, despite the fact that we're the ones that make physiology law and make medical science law. The Bar Association has routinely sworn in physicians and medical scientists as expert witnesses in cases and not taken that next step to have us oversee cases. We're good enough to be expert witnesses. That means we're good enough to be judges. It begs the question, why not make physicians and medical scientists a judge? We're talking about that today on Hard Knock Right. A magistrate judge system, reintroducing the old Kent English tradition of Sir Henry Vaughan, who founded Harvard University. Sir Francis Bacon, the noted empiricist that founded the Baconian method, the scientific method, empiricism. And Josiah Bartlett, who signed the Declaration of Independence for the state of New Hampshire. States created an inside lane in their drug courts in protecting drug criminals. But states didn't create an inside lane for physicians, our best and brightest. Physicians, in the Kent English tradition, may benefit from an inside lane for you. The Kent English magistrate judge system is that inside lane that physicians deserve. We know that medical science is harder on physicians. Medical science has always been the judge of physicians. The Kent English magistrate is of the 65 to 102 Hippocratic traditions, the 65 to 102 Superior and Horses traditions, the 65 to 102 Good Shepherd traditions. In our reporting today, the ABA failed to return correspondence by our deadline. America has a learning lab tradition. The learning lab tradition of American states needs magistrate judges, needs these new solutions to malpractice. If there's not a public magistrate judge solution, there will be a private one. Physician medical scientists have the right to oversee malpractice cases. We don't import medical clairvoyants, mystics, fortune tellers, voodoo medicine to undermine our rule of law. We send physicians in like Doctors Without Borders to oversee cases in our empirical tradition rather than with voodoo medicine. The ABA is practicing voodoo medicine in the litigation, the judging and adjudication of cases that have medical science at stake, that have physiology at stake, that have malpractice at stake. We don't import medical clairvoyance and voodoo medicine into our courts. We shouldn't import them from the ABA. We're reporting today on Hard Knock Right, the need for magistrate judges in the Kent English tradition.